Yeah, so just wanted to share a little bit about regulatory updates in the state of New Mexico. I think the last few weeks there's been a lot of discussion about regulatory activity in the state, and so I think it's a useful moment to talk about this particular topic. Before I get into that, though, I wanted to just give a little bit of background on the WATR Alliance. So I'm here on behalf of the WATR Alliance. The WATR Alliance is a relatively new organization headquartered in the state of New Mexico. WATR stands for Water Access, Treatment, and Reuse. Jennifer Bradfeud and I started the organization last year on the heels of the governor's 50-year Water Action Plan. And I think a way to talk about why we started this organization takes me to West Virginia. When I was in law school, we drove through West Virginia, and if you've driven through West Virginia, when you enter West Virginia, they have signs that say, "Welcome to West Virginia," and then with that sign that says, "Open for business." And in New Mexico, if you look at the 50-year Water Action Plan, one of the striking conclusions is over the next 50 years, we'll see a 25% reduction in our available water. And so unless we do something, the signs entering New Mexico will say close for business. Because without water, we can't, we'll see 25% reduction in a number of things, right? Households, jobs, attracting new markets to the state of New Mexico. So that's part of what motivated us to start the WATR Alliance. We have some board members and members of the Alliance in the room. The organization is comprised of various water stakeholders from around New Mexico and the broader Southwest, some from oil and gas industry, agricultural stakeholders, municipalities, engineering outfits like Bechtel, Veolia, so water treatment providers, so a broad collection of stakeholders interested in water reuse. In terms of what we are working on, it's advocating for the reuse of these non-traditional water resources. So we're focusing primarily on treated produced water, brackish water, municipal effluent, as kind of our primary water categories. And so just relating to those three topics in particular, I think it's important to note, because this is relevant to regulatory updates and regulatory activity in the state. In the United States, we have around 650 brackish groundwater treatment facilities. We have 0 in the state of New Mexico, besides the research facility that we have, right? And
Alamogordo.
Exactly.
Alamogordo has 1, only half a million gallons a day.
Yeah, at the peaking plant though, right?
Yeah, and municipal effluent in New Mexico is reusing approximately, we were talking about this, Susan and I, it's a low number, whatever it is, but we'll call it plus or minus 15 to 20% of our municipal effluent is reused. And then in the context of produced water, outside of the oil and gas field, we know that we're reusing none of that. I think for context, we also, I think folks in the room are aware of this. Texas has applications pending to reuse, plus or minus 500,000 barrels a day of treated produced water, which people should always check my math, but I think that is around 25,000 acre feet of water, non-trivial amount of water. That's for the most part New Mexico water, right? That particular application, the NGL application, will primarily be NGL or New Mexico water moving across the border into Texas to be treated and reused, put into the reservoir there. So we are working on those primarily in our early years here as the WATR Alliance. We're focusing on those water types because we think there's an opportunity there for the state of New Mexico. We just got back actually from we held an event in Midland. Some folks in the room were there where we visited the Aquafortis treatment facility. We visited one of the Midland well fields, and a hydrosource infield recycle facility. And when we were there in Texas, I'm thinking about the conversations that were going to happen here. I think it's relevant to remind us sitting here in the state of New Mexico why the focus on regulations is so important. One of the regulatory updates / legal updates that we've observed over the last decade, and John D'Antonio stepped out of the room, I think, so it's safer to say this now. But prior to plus or minus 2015, 2020, it wasn't clear under the law whether or not groundwater was covered by the Rio Grande Compact, right? But over the last decade, as that litigation has moved forward, what's become clear is that it is covered. On the New Mexico side, right? Texas regulates their groundwater under the rule of capture, which means they pull as much water as they can, unless otherwise limited by their groundwater conservation districts, which don't exist in all places. And along the Texas-New Mexico border, there are counties where there is no conservation district, so there's zero restriction on your ability to pull up groundwater. On the New Mexico side, that's not the case, right? We're governed by the rule of prior appropriation. Furthermore, under the Texas-New Mexico, under the Rio Grande Compact, New Mexico has a delivery obligation. And under the litigation, we've learned that groundwater is related. We must regulate our groundwater withdrawals in New Mexico because that is pulling the surface water, right? So to protect the delivery obligation we have, we must curtail our groundwater withdrawals in New Mexico. Again, on the Texas side, that's not necessary. So that's super relevant when we think about protecting New Mexico waters and what water we have available. Texas is not limited the way New Mexico is, using some of our available waters. I think also relevant, thinking about Texas and New Mexico, this week, the Texas legislature ended their 6-month session, and they passed a joint resolution proposing to move $20 billion to water resources and water infrastructure. $20 billion over 20 years, so $1 billion a year. I think that they finished, the final number is that 80% of that will be directed towards finding new water, brackish water desalinization, and treated produced water. That should motivate us in New Mexico to be more aggressive in looking at the water resources we have and seeing what we need to do to use them before Texas just takes them. Right now, we're sending plus or minus 3 million barrels a day of produced water to Texas. Right? That water will not come back. Texas will take that, we'll treat it, and we'll use it. We won't get it back. That's free water for Texas that was New Mexico's water. Okay, so I think that these facts are really important and really relevant. I think we need to remind ourselves from time to time as we think about what laws and regulations we have in New Mexico and what potential changes we need to look at to make sure that we're using the resources we have and protecting the resources we have. So with that kind of table setting, a little brief discussion, because I imagine Jason will get more into this. But the Water Quality Control Commission, the rule that they voted on a few weeks ago, as folks in the room I'm sure for the most part have heard, prohibits the discharge of treated produced water into surface waters or groundwaters. We could quibble about the relevancy of that particular change in the rule. Before that rule, could you discharge into a surface or groundwater in the state of New Mexico? You could make an application, right? You could apply to discharge to a groundwater. Would Jason, would that permit be granted? Probably not. Could you discharge to a surface water? Well, you could apply to the EPA, right, for a NPDES permit. It would come to the state of New Mexico for certification, and would the Environment Department have certified that application? Probably not, right? So while that change is now, will be codified in our, code of regulations, I don't think it's an incredibly meaningful change. You cannot discharge right now into surface or groundwaters in the state of New Mexico. Potentially more meaningful in the immediate future, I think, is the change that the rule made to how you go about permitting or getting authorization for a pilot project. A few weeks ago, I'm not sure what you would do today. A few weeks ago, you would use the notice of intent process, working with the Environment Department to authorize your pilot project. Under the rule, there is now a pilot project permit program. Wow, a lot of P's. And you would need to take your application through that process to get authorization from the Environment Department, and that process is more robust. It's going to require you to follow some of the existing discharge requirements that are imposed on applications for discharge under the current regulatory structure. In my opinion, those are the real meaningful pieces of that rule as it pertains to produced water. Another reason, but kind of the last thing I want to talk about, and this is why perhaps my opinion on that rulemaking is what it is, which is, again, to me it seems a little bit like much ado about nothing, is because the Environment Department all along was saying this is phase one, right? We knew 3 years ago that the Environment Department was working on a prohibitory rule, and that was the rule. They announced that when they brought the rule, this is going to be a prohibitory rule. And what did we get? We got a prohibitory rule and be like, what in the world? Well, that's what they said all along. What they said before that as well is that there will be a phase two. And phase two is lists and limits, it's standards to facilitate reuse. And that's where we find ourselves now, is looking forward at rulemakings that would establish a program authorizing reuse. We don't have a rule right now. We don't have a draft rule. But the Water Alliance has been working on a draft rule that we intend to bring to the Water Quality Control Commission in the form of a petition in the next 60 to 90 days. And so I wanted to give you just a little bit of a preview as to what we're working on with that rule. There are folks in this room who have been incredibly valuable in helping us put together some of the technical pieces of that. But wanted to give you just a preview of kind of the structure of that rule. And happy to talk to anyone who has questions about it later. But it's a robust collection of words on paper. And so what we've set out is two pieces of permitting, kind of two pathways to permit a reuse scenario. One is a general permit. And under the general permit, for particular uses where you arguably have little to no exposure pathways to human health or the environment, then you're able to pursue a general permit. And then for uses where you do have an exposure pathway, we've proposed an individual permitting program. And for those uses are, this probably not be terribly surprising to people, non-food crop, irrigation, surface and groundwater discharge, indirect potable reuse are the three kind of big ones. And the way that we have set up the rule is, this part is very administrative. You make an application, you need to provide an operations plan, you need to provide an engineering plan, you need to provide release prevention and response plan, and there's a healthy list of requirements in terms of what would be needed to be included in those various plans and reports. But then you get into what is the real challenging part of the rule, right? The monitoring and testing regime that you would need to comply with in order to move forward with a reuse application. And this is the part where we've been working with a group of technical experts, some of whom are here, all of whom are known and incredibly intelligent people. And so what we've got set up right now is a tiered monitoring structure. And how it's set up is you have your real-time monitoring, and I'm going to pull it up here so I can actually read some of this to you. So under the real-time monitoring, these are things that, again, probably won't surprise people, but your real-time monitoring would be for temperature, pH, electrical conductivity, dissolved oxygen, turbidity, total organic carbon. And under the scheme, if you your real-time monitoring, if you stay within certain parameters, then you're good. If if your results from your monitoring indicate that you're moving outside normal parameters, then there's going to be some action required to make sure that you're not to troubleshoot whatever that issue may be. Then we have some weekly and monthly testing. And this would be total dissolved solids, total ammonia, boron, sodium, chloride, hardness, gross alpha beta, benzene, your BTEX, and polycyclic aromatic hydrocarbons. And similarly, there'll be parameters, and as long as you're staying within those parameters, again, this is not novel. We're following models used by other water quality permitting regimes. We've looked a lot at Colorado, a lot at California. California's new direct potable reuse rule. So picking up models and approaches to monitoring or to managing water quality that we see elsewhere in the space. And then additionally, there is a presently quarterly whole effluent toxicity test requirement. And I think that no, and then the other monitoring piece that we've talked about is looking at some frequency of non-targeted analysis to continue to motivate and incent a permitted entity to continue working with folks like Pei and her team, so that they're incented to provide water on an ongoing basis. So continue to look at this water and learn from this water, and that's something that we picked up from California. They have a working group that is looking at contaminants of emerging concern to make sure that their regulations and their permits adjust when necessary and appropriate to accommodate and respond to emerging contaminants. So that in a nutshell is the monitoring and testing regime. I think some other pieces just to mention, and then I'll wrap up. Financial assurance is a really important piece of a program like this, and so we have, it should surprise no one, a financial assurance component of the rule under which you would need to provide cost estimates for closure, post-closure, and corrective action. And so it looks and feels a lot like financial assurance that we would see in other contexts, where your financial assurance matches the estimated cost of managing closure, post-closure, and corrective action. And as I said, the intent is to polish this draft and bring a petition within the next 60 days, plus or minus. And I think it's really important to note that this has not been work we've done in a silo. We've been looking for and engaging with a lot of third parties. Feedback is really important because this is obviously going to go through a public process, and we'd rather get as much feedback as we can before we take it to the commission, and have a better product that we take to the commission when we take it. That's it.
There was a question online for you from Melissa. You said you looked at CO regs. CO requires full chemical disclosure, no trade secrets. Will you draft a rule included the requirement to disclose chemicals used in operations from which produced water is sourced for treatment and reuse in New Mexico?
Yeah, super important question. We've talked a lot about that. And I'm flirting with the edge of my competencies here, so anyone in the room can jump in and correct me here. But as we've talked about that, what I've learned is that the frac chemical disclosure and the sensitivities about frac chemicals is a real one. However, in some ways, it's and Fred, I'm going to look at you in a minute here. It's a concern that perhaps we've given more credence than it deserves, because the chemicals, the frac chemicals, are chemicals of concern, but there are production chemicals that are also chemicals of concern. And so what we've tried to do is build a rule that requires a treatment train, a treatment process that is robust enough that you're capturing all of those chemicals, whether they be frac chemicals or production chemicals. That being said, we appreciate that there is sincere and intense interest in those frac chemicals. And so this is, why I say our rule is not yet final. We're having conversations with, pieces of the industry that work on that issue. Some of the service companies who are providing those chemicals. The sensitivity, historically, as we've seen in, every state that's talked about this, is, proprietary chemicals and protecting IP around those chemicals. And so there's a reluctance to share all of that data. We think that there's a sweet spot where we can get some disclosure such that we know what is in there without having to disclose the proprietary pieces of those chemical recipes. So that's an imperfect answer. I think I see Michael, were you raising your hand?
I was just going to add that we've discussed this recently, and David Rose, from Colorado School of Mines, has done some more work with this group here, right? And he pointed out that there was a sample that he had that was showing us the non-target analysis he had done, and showed a spike of something that was unexpected in this water, right? This non-target analysis helped identify these things, went through the literature and found that it was a common biocide basically used in industry, right? If they're showing up in concentrations that are high enough, we can find them, in this water. If they're showing up in any measurable concentration, and it wasn't showing up in the treated water, they were showing up in the feed water into a desalination pilot. And he found it, and they were able to identify it and trace it back. And if it's showing up in any measurable concentration, but he's not targeting another analysis, but if it's constant enough to affect the wet testing results, right? There are other ways to, a trade name of a chemical is not the answer to how do we, find contaminants of concern in this water. It's the testing that the research universities like, the consortium here are doing will identify anything of concern in this water. It was just one example I wanted to share of kind of how we can backtrack to what is the contaminant of concern.
So I have a question. Is it written slightly differently for discharges of treated produced water versus non-discharges? In other words, for an industrial application where you're not going to discharge to the environment, are there going to be different levels?
Yeah, so, and what we've done, and I say we, there's the group working on this, the way we've kind of structured it right now is we've used, and I actually missed this part before, we've incorporated the NPDES Plus list, maybe we're calling it plus list at this point, but we've incorporated that list into the rule right now, requiring, again, subject to change, some frequency of targeted testing under the NPDES Plus list. And I just lost your question, Mike.
What about for non-discharge?
Yeah, so, and on that list, we have effluent limits, right? And we've got a range. And so it'll be a bit of a negotiation and conversation to some degree between the applicant and the Environment Department, where we say, they bring their feasibility study data. They say, this is our project, this is the water, this is the water quality we're able to achieve, this is the results. As we look at the NPDES Plus list, we see non-detective, these analytes, and here's where we're able to, what we're able to get for all these other analytes. And so then the permit would look at the feasibility study data and then incorporate permit limits that are within the range that are in the rule that are appropriate for that reuse scenario. Super easy.
Sounds fairly straightforward.
Am I next? Yeah. My question is, in a more, maybe a bit of a shift, from the perspective of someone trying to bring new technology, breathe life into new technology. Some of your phase 2 descriptions sound like that's something for someone who's an established company with capital resources and a big bank account. That's not the general characteristics of we startups.
Fair point. And I'm just going to tell you my thoughts on that. And this this is just me speaking. This is a very complex regulatory area, one where failure, the risk of failure is, I shouldn't say, the consequence of failure is non-trivial, right? And so I think some of these, we can actually call them regulatory barriers to entry. I think some of those are necessary. The financial assurance component is a non-trivial one, but I think it's necessary to offset, again, the potential, the consequence of a failure event. I'm not sure how else to develop a program, a regulatory program that would be protective of human health and the environment, without some of these types of pieces. It's an imperfect answer. Again, I have a lot of imperfect answers. Yeah.
So I do have another question and follow up to Hills. Is there a way, and I'm sure that you've been talking to communities where economic development departments in certain counties, that they might be interested in working with technology to maybe help them through as an opportunity for that community or that economic development group to get additional water resources, potentially. And then they also then have some liability because it's a not-for-profit, it's a community. So have you seen from the communities that you've dealt with, and I know that there's a lot of community leaders on water that would be willing to work with a startup and say, hey, we'll put up X amount of dollars for bonds or something to get you started because this looks good, and take on some of that liability for a startup in New Mexico that looks like it's pretty good. Is that a possibility that may be available to startups?
Yeah.
It's a question, possibly.
I think it's a question and an answer. I think.
That might be the right way to go for some of these startups, you're saying?
Yep.
Okay.
WQ, okay, thank you. What are the reasons that WQCC did not allow the surface water discharge or groundwater discharge? Are there any possibilities if there are more data or science presented that could make them to reconsider their decision? And what would be the timeline for them to reconsider their decision?
Yeah. For them to reconsider their decision, well, I don't think they will reconsider their decision. A party to the rulemaking could appeal their decision, but that would essentially result in a court, saying that that their decision was not appropriate for some reason, be it legal or technical. So I don't necessarily think there's a immediate path forward for the WQCC to reconsider their vote on that particular rule. But again, I'm not sure if it matters, because the rulemaking that comes next, whoever brings it, whoever brings that rulemaking petition that says our proposal is that water, someone should be able to apply to reuse water for non-consumable agriculture. And then the WQCC will say, okay, show us the data. And then they'll put on the data as part of the hearing, and then the commission will say, we agree. And so here's a new rule, you can do that. Or they'll say, we don't agree because we don't think your data is sufficient. So I think that's the next step, is bringing that next iteration of a reuse rule, where the proposal is to reuse the water, whereas the last proposal was not. It really was never proposed in the rule to discharge or reuse. One of the parties tried to argue that they should incorporate that in, but it wasn't the case was never made with data to support that argument. Thanks.
Oh, there's two online. We'll get to you in a sec, Brian. Which ones are, okay, I'm gonna start from the back. It's an anonymous attendee. Where did the numerical targets in the proposed standard come from?
All over. The technical group that's continuing to work on this, standards have come from all over the country. EPA standards, other state standards. So we've looked at peer states, federal standards. So it's a comprehensive examination of standards across the country.
Great. And then last one from online is Colorado is full public disclosure. Why is this not possible in New Mexico if industry already does this to the north? I don't know if that was.
Yeah, I think that's the same questioner from before. And what Colorado did was not without consequence. And once again, I'm flirting with the edges of my competency, so I'm gonna glance at Fred. But in Colorado, Colorado is a different operating environment to begin with. But there are newer, more sophisticated, and the term I'm going to use because this is the term that I've heard others use is they're greener solutions that are being used to hydraulic as part of the frac solution. Those are no longer being used in Colorado because they're newer, and full disclosure in Colorado means that they must disclose those newer solutions, and they do not want to risk the IP associated with that, so they're not using those in Colorado. They're using older chemicals such that Colorado is not benefiting from the more advanced, sophisticated chemical solutions. Again, I don't want to trivialize that issue because I do think it's an important one. There'll be a lot of public interest in disclosure, and so it's one we're talking about. We have had conversations about different approaches to managing that. Some are, maybe you just prohibit flowback water from being part of the reuse, the scope of water that can be reused. But that's where some folks said, well, that's arbitrary because you have production chemical that is equally concerning as your flowback, some of the flowback chemicals. So why would you make that arbitrary? The science and the data don't support that type of a decision. In that case, we would be responding to, kind of public interest that wasn't fully informed. And so we're trying to make sure that the rules that end up on paper are fully informed and while simultaneously being responsive to, public interest, because if you have a regulatory license to move forward without a social license, you're not going to get very far. So the questions about what Colorado has done and what we are intending or would propose to do are alive right now. And whoever that is, I'm not sure. I would love to talk to them because we're working on this as we speak, and we want to get it right.
Okay. I was just kind of looking at this maybe in the crystal ball kind of thing, and kind of going to what Jerry was talking about a little bit earlier about how to be a leader and create these.
Don't ask me a hard question because I don't have a PhD like Jerry.
Yeah, me neither. But I do have a posthole digger. I'm no farm boy. Anyway, coming along with that aspect of it is, overall I see, as somebody trying to help provide a solution, the state here, like Pennsylvania, it looks at production water as trash. And it's better to give your neighbor your trash than take care of what you created yourself. And so what we're trying to do with these various technologies and answers are here coming in to provide you opportunities because, for instance, as you were saying, your aquifers are becoming depleted. The numbers you mentioned seem to be quite conservative as far as some of the other ones that I've read coming out of the DOE and so forth. So you're going to be running out of water real quickly. So when you send your trash to Texas, it ain't coming back. And sooner or later, you're going to find out, well, we aren't going to be able to support the oil and gas industry. And then you're going to find out, well, we got not enough water to support these other industries. And then the next thing you know, the state will not have any industries. You'll basically become a great big gated community, which will then only be able to hold so many people until it dries up. The Ogallala, these aquifers are not going to refill themselves. So if continue, the thing, well, Pennsylvania has on you, they got plenty of water. You guys don't. And so we're here to help you. And that's what we're coming here as far as a kind of a crystal ball. How long is this going to last? You're saying 30 to 50 years, you're going to be in trouble.